Hello, we've got a big topic in front of us now with contracts and agency, and I'm going to dive into with state specific information for Iowa. Salespersons, you're going to have 13 questions around contracts and agency, and brokers, you will have 9. Now, I'm going to say a good review for you would be to go under principles of agency and contracts on the national as well. Because there's a lot of those things that just a generic, what makes a contract are going to be valid here in Iowa. But I did want to break out some things for you specifically. And let's actually start with agency, because before we write a contract, we need to establish that. I think it's really good on the state information for you as an developing agency preparing for questions, need to review COLD AC, care, obedience, loyalty, disclosure, accounting, and confidentiality. Next is, I think we should talk about specific assistance versus ministerial acts. Ministerial acts as an agent would be showing a house, answering a phone call, someone asks you the price of your listing, hosting an open house. Those are just basic functions. Those are ministerial acts. Where we cross over into specific assistance is when we learn something about a client that could put them at a disadvantage when negotiating. So I would know those definitions. A couple of other things that I want to know. Dual agency must be disclosed. There should also always be a section in a dual agency contract, which is usually pre-written for you, so you don't have to worry about it. But it is required by law that there be some sort of a comment that says representing more than one party in a transaction could create a conflict because you're relying on one agent for information. The other thing for agency is, can you represent yourself or immediate family in a transaction? And the law says, yes, you can represent yourself or immediate family as long as you disclose it to all parties. The last one that I'm going to mention is commission or compensation. Just because the seller pays compensation to the buyer's agent, that does not constitute any form of agency. So for example, if I were to sell a for sale by owner, and I had them sign a form that said, for sale by owner, unrepresented seller. I, Amy Schaefer, represent Jane and John Doe in the purchase of 123 Main Street. Seller still retains the right to represent themselves solely, for example. But then I maybe ask the seller to compensate me on behalf of the buyer for my services. And just because the seller agrees to do that does not mean I owe them any sort of agency. I'm still representing the buyer. Now, contracts, again, I would review the contract section because I think that will help you a lot with state. But let me rise some things to top for you. All contracts should be in writing. That's a statute of frauds requirement. And all offers should be presented immediately for either acceptance or rejection from the seller. You've got 3 types of exclusive contracts or agency: exclusive right to sell, exclusive agency, and buyer exclusive agency. Anything with the term exclusive in it, if you're asked when you can approach that client, if you know they have an unexpired contract, when can you solicit them for business? The answer is you can't until that contract expires, unless the client approaches you first. And you could be asked a question like this more than once. Don't assume that you're being asked that more than once because you flopped the first time you answered. Nope, you just randomly got 3. But anything with exclusive in the title, exclusive right to sell, exclusive agency or buyer exclusive agency. That means they hire only one agent. And if they are in a written contract that's unexpired, you cannot solicit them for business unless they approach you first. Another area is, when does your duties to the client terminate in an agency or a listing contract? And there are many answers, just like there were for national. Death or incapacitation of either party, which means broker or client, not you as a salesperson. Expiration, mutual agreement, or the big ticket one is completion. You did your job, you had a closing. So if I had a contract or an agency contract with someone January 1st to June 30th, and I sold their house April 1st, I don't owe them any duties April when it closed until the end of June, because I did my job. Broker protective clauses. Again, this is what protects you from the seller going out after your listing expires and approaching the buyers you created during your marketing and trying to sell it directly to them. A broker protection clause by Iowa needs three things. One, it needs to be a part of the original listing agreement, which it is already pre-written for you in there for your listing agreements with your brokerages. So you won't have to remember it. But it's got to be a part of the original listing agreement. Next, it's got to have a deadline after the expiration. So once this expires on February 14th at 11:59 p.m., how many days after that do you have in this protected time? And that could be, as a negotiable item. I've seen 30 days, 180 days, but it must have a time frame in it. And then the third element for Iowa is, in order for you to protect those buyers, you must give a copy of the buyer's contact information to the seller prior to the listing expiring, prior to expiration. And then another big one for you is dual contracts. And this is different than dual agency. Dual agency is where we represent both parties in the same transaction. Dual contracts happens when I write one contract to the seller for $300,000, and then I write one contract I show the lender for $400,000, and then I'm trying to pocket $100,000. That is illegal to do in Iowa, but by the way, it's also mortgage fraud. So don't do it. So again, I know I'm giving you a very small snapshot, but these are the things that kind of rise to the top for Iowa. Otherwise, again, please go back and review those agency and contract videos under national. I think they'll be helpful for you as well. Thanks again.